Hello, my name is Matthew Talbot and I'm a probate attorney in Walnut Creek, California. And today we're going to talk about the sale of real property in a probate. Now, I just want to be clear that when we're talking about a probate, we're talking about a situation where someone has died and they didn't have a trust, or they had more than $150,000 worth of assets outside of the trust. So in the Bay Area where we're located, that's pretty much any home. So if you're looking to sell a home, then there's two types of authority that people have in a probate: full authority or limited authority. Full authority is when people have sufficient credit and other assets to be what's called fully bonded. That's where the required insurance policy of a bond can be in line with the assets that exist within the estate. Sometimes, however, people don't have the credit or don't have the assets to be bonded. They cannot take out the required insurance policy, and then they have to have limited authority. And there's a lot more to that, but I will just say that there's two types of ways for sale. So the first type of way for sale, under the full authority, does not require you to go to court. You send out what's called a notice of proposed action. This document outlines specific key terms about the sale, such as the price, the commission for the realtor, any appraisal values. And what we end up with there is a 15-day time period in which any beneficiaries can potentially object. Now, oftentimes this does not delay the sale because the 15-day time period and the escrow period can run in parallel. And if people don't object, then they have deemed to have tacitly consented to the sale. And in that circumstance, escrow will close the sale because of the tacit consent of all beneficiaries. If they do object, then you have to go to court to do the process, which I will now describe in relationship to the limited authority. If the client who here has limited authority, then they generally cannot get bonded. You have to go to court, and with that you have to do a few things. You have to file a petition, which is generally set about 6 to 8 weeks out, to approve the sale. You have to publish information about that petition in a local newspaper. This is a bit archaic. Maybe today it'd be better to tweet it out or put it on Facebook, but this is how it's done under the law. You have to publish this information. You have to mail copies to all the beneficiaries of the petition for sale. And then, when it comes time for the sale itself, at the court hearing, people can show up and what's called overbid. So let's say you're going to sell the property for $1 million. Somebody could show up and put in more than $1 million. And a bidding war, and I've seen this happen on multiple occasions over my 11 plus years, a bidding war can break out where people are there and they're saying, I'll pay this amount, well, I'll pay that amount. And it's like an auction house. And the judge will provide the sale to generally the highest bidder on the best terms. And so people get nervous if they have to go to court to sell the property because it can lead to people swooping in and there being overbids. Now this might be good for the estate because the value from the sale increases, but buyers get skiddish and sometimes give worse offers because they have to plan for potential overbids. So if it's a possibility to avoid limited authority and a possibility to avoid going to court with the sale of the real property, that's something that you always want to try to do, because then it just goes out in the informal notice, you wait the 15 days, and hopefully everything closes very smoothly. Thank you very much.